Thank you. Good afternoon, ladies and gentlemen. It's very good to see all of you, so many of you here today. Very good to see so many familiar faces in the crowd. Especially good to see friends in the crowd, all the way from Pasir Gudang and Kota Kinabalu. Okay, I know we're running short of time. I've been given the timer here. I assure you I will stop when the timer stops, even if I'm in the middle of a sentence. Okay, first of all, please allow me to acknowledge my colleagues who, Elvery Teo and James Gunn, who very kindly did all the research for this paper and prepared the wonderful Prezi slides that you will see. Okay? Okay, I know it's the second day of your conference, okay, and your concentration may not be at optimum level now. So I have a small exercise to freshen the mind, okay? Don't worry, it doesn't involve anything physical. In fact, I have to do most of the work, okay? I've been doing a lot of yoga lately, so I'm all into breathing and clearing the mind. Okay, so it only takes 2 minutes. Clear your mind, take a deep breath. All right, clear your mind. Pick a number from 1 to 9. Hold it in your mind. I want to read it. Pick a number from 1 to 9. Multiply that number by 9 times 9. Those of you in Chinese school are finished. Now you have a number that is either a single digit or a double digit. If you have a double digit number, add the 2 digits together. Add up the 2 digits. Now deduct 5. Okay? Are you done? Minus 5. Okay. Now, imagine each number corresponds to an alphabet. 1 corresponds to A, 2 to B, 3 is C, 4 is D, and so on and so forth. So assign the number in your mind to an alphabet. Now take that alphabet and think of a country that begins with that alphabet. A country name. Got it? With that country name, take the second letter from that country. You got the second letter? Think of an animal that starts with that letter. Now think of the color of that animal. I'm reading your mind and I'm seeing the color gray. Thank you, ladies and gentlemen. Now let's get to the real reason why I'm here today. Okay, my topic on terminating for non-performance today, ladies and gentlemen, I want to focus on two main areas. First, I want to share with you the concept on positive approach for managing poor performance. Yeah, positive approach. And secondly, I will run through some case laws, industrial court cases with you to identify where is it that employers have gone wrong. Why do some employers lose their poor performance cases in the industrial court, other than because you didn't hire me? Okay, just kidding. Right, so let's start with the first concept, positive approach. To understand this concept, you need to look at the difference between poor performance and misconduct. Poor performance versus misconduct. It is important not to confuse poor performance with misconduct because the two requires very different legal process, right? As you know, poor performance deals with issues that are relating to unsatisfactory work performance, poor quality of work, low productivity. And poor performance, the legal requirements require you to take positive steps to help improve performance. As opposed to misconduct, which is to do with wrongdoing at the workplace, breach of policies and procedures at the workplace, that requires you to take a negative approach to prove the misconduct. Are you with me? Okay, so if you apply, so misconduct, when you deal with a misconduct case, you are focusing on investigation, looking for evidence to find the employee guilty of the misconduct. Am I right? So you would even, in your investigation, focus on looking for evidence and documents and facts to challenge the employee's explanations or rebut his defense. That is very different from poor performance. The legal process for poor performance, if you adopt a negative approach, you will find that you will likely lose your case in court because you adopt the negative approach. And I'll tell you why. Because poor performance requires you to look at what are the weaknesses in the performance of the employee. It then requires you to find out what are the causes of those areas of weakness in performance, and then take positive actions to help the employee improve. Only if the employee fails to improve after these positive steps, then only can you terminate. Right? So the difference in the positive and negative approach is important to be clear on this difference. And I tell you, the case of Wern Brothers Services explains this very clearly. Yeah? It was argued on behalf of the claimant that the allegation against the claimant being one of inefficiency, it required the company to hold an inquiry as dismissal was effected as a punishment for the failure of the claimant in the eyes of the company to improve his work performance. The court says, I am of the view that inefficiency is not a misconduct which necessitated an inquiry. So for poor performance, you instead of show cause letter and domestic inquiry and proving the employee is guilty of something or proving that the employee is performing poorly, what you do or what the law requires you to do is set out in the case of Eureka Construction. So to summarize from Eureka Construction, what you need to do is, firstly, it's a 3-limb test, we call it. Firstly, you need to warn the employee or bring to the employee's attention the areas of poor performance, right? Secondly, you need to give sufficient opportunity to the employee to improve. And that includes counseling, motivating, training, coaching, etc. Sufficient opportunity to improve. So all the positive steps, all the positive actions that I'm talking about. Then, if the employee still fails to improve, only then can you terminate. So that's the legal test set out in Eureka Construction, very different from a misconduct, the legal test for misconduct. Okay? Now, in the next few slides, ladies and gentlemen, I have extracted a chart from a publication by the Fair Work Ombudsman of the Australian government. The publication is entitled Best Practice Guide for Managing Underperformance. This publication is available on the Fair Work Ombudsman website, and the reference is footnoted in my paper. I'm not sure if it's in your paper. If not, you can go to the website and easily download it. Okay? The chart that I have extracted show 3 columns. You have common performance issues, you have possible causes, and recommended actions. So for example, the first issue I have on the chart here, employee does not undertake work as required, showing signs of apathy and laziness. Sounds like a familiar poor performance issue. Employee does not appear to understand job requirements or directions. So then you look at, if that was the issue of poor performance, then you look at what are the possible causes. Is it because job content and design? Is it because inappropriate job fit? Personal or external issues? So having identified the possible causes for this performance issue, the recommended actions would be one of these few, or all of these. It could be, you might want to begin with informal performance discussion, be clear about the performance requirements and expected contribution of the role to the work of the business, focus on interest in work tasks and how they might be improved, explore options for opportunities in other areas of the business if possible, refer to counseling service if personal circumstances are impacting performance. Now, I don't have time to share other parts of this chart with you because the clock is, and I started late. But you can certainly look at this in the website. But what I want to share with you is the best practice guide from Fair Work Australia helps you to fulfill the legal requirements, the legal procedure as set out in the Eureka construction case and the roof tech case, right? The roof tech case is another case in poor performance which is often quoted by the industrial court. And this is what roof tech says, right? So if you remember nothing from this talk apart from the grey elephant from Denmark, you remember Eureka and roof tech, okay? Roof tech says this: inefficiency which discloses a cause of negative conduct, no doubt is a sufficient ground for termination, but there must necessarily be sufficient proof that a procedure has been followed. This is the positive approach procedure that I'm talking about. The court is looking for this. The court is not looking for you to prove that your employee has performed poorly. The court is looking for you to show what you have done in respect of that poor performance to help the employee improve before you terminate. Ordinarily, there must be sufficient written communications to the claimant in order to establish inefficiency or poor performance before the company can rely on it to justify dismissal. Okay, so now bearing in mind, and I can read your mind, remember? Bearing in mind the legal principles for establishing poor performance, namely giving warning or alerting the employee about the area of poor performance, then giving sufficient opportunity to improve, failing which then you can terminate. Bearing that in mind, those principles, I will now share with you, we will look through some industrial court cases to see how the courts have applied the Eureka construction principles. Okay? So we start with Cisco Malaysia, Sdn Bhd and Raja Mohan. In this case, the industrial court suggested that the standard imposed on an employee to achieve certain results must be reasonable. So your KPIs, your sales targets, the court will look at the reasonableness of it. So in the Raja Mohan case, Cisco Malaysia Sdn Bhd case, Raja Mohan was the senior manager for systems and technology. One of his job functions was the sale of security seals and systems contracts. I have no idea what those are. The company set a sales target of 1 million ringgit for seals and 2 million ringgit for systems. The company found that the Raja Mohan had failed to achieve those targets and terminated his services for poor performance. And this is what the court said. The court said, in the absence of any specific sales targets being specified in the claimant's letter of appointment or in any other document, it is totally unjust for the company to consider that the work performance of the claimant was poor or unsatisfactory. It would also be unrealistic and grossly harsh and unjust for the company to require the claimant to achieve such a high sales figure in the face of adverse economic circumstances during the 1997 and 1998 period. So from the Cisco case, you know that there is a need to apply reasonableness to the targets that you set, depending on the economic conditions, depending on things that are happening to the business. Okay? I'm just stealing some time to... Okay, now let's look at warnings. Must warnings be in writing? What about verbal reminders? Is 3 warnings the magic number? In the next few slides, I hope to answer all these questions, right? In the case of American Malaysian Life against Siva Nason, the company terminated the services of the claimant for his uncooperative behavior and that he was not a team player. So nothing to do with KPI or sales target. Something to do with the boss doesn't like your face. right? Uncooperative behavior, not a team player. So the court struck down the dismissal and held that the allegations made against the claimant in the letter of termination and in the statement of reply were bare allegations, and the company failed to produce any evidence to cite that the claimant was uncooperative and willfully refused to be a team player. In order to justify the claimant's dismissal on the grounds of unsatisfactory work, inefficiency, or failure to come up to the standards set by the company, there must be oral or written warnings. The company has failed to show such. So from this case, we know warnings can be oral or in writing. Of course, in writing, it's better evidence. But more importantly, there must be evidence of unsatisfactory performance, right? Bare allegations will not do. He said, she said cannot stand in court, right? Okay, moving on. In the next case, you have Rohimi Yusuf and Alpha Meli marketing case. This is a case where the employee was dismissed without any warning and only after 10 weeks in employment. This is where the employer failed the second limb test, right? Which is the need to give sufficient opportunity to improve. The court held that the dismissal was unjust because of the absence of any warning and that the 10-week period was too early to say that the claimant was a poor performer. So here the company was not able to satisfy the sufficient opportunity test. Okay? Now, ladies and gentlemen, there's a myth that there must be 3 warnings before termination. 3 is not the magic number. I'm telling you, 3 is not the magic number, right? The test in Eureka doesn't specify that you must have 3 written warnings. So in the case of Muhammad Jamil and Prima Union, the company made the mistake of rushing to issue 3 written warnings in a span of 1 month. Rushing to terminate, because somebody told them you must give 3 written warnings. So what happened? The court held that the 3 warnings did not mean that sufficient opportunity was given to the employee to improve. The court said this: the respondent did not give adequate opportunity to enable the claimant to improve his work performance between the periods of CL4 and CL5. So that's the first warning and the second warning. And between the second warning and the third warning. The said warning letters were issued within a span of 1 month without affording sufficient time for him to rectify his alleged shortcomings with regard to his work performance and quality of work if the said allegations were found to be true. So there you have it. 3 is not the magic number. What about when you transfer an employee from one department to another? Must you give sufficient opportunity and sufficient warning to the employee when he is performing poorly in the new department? Yes. In the case of Citibank and Cheng Kam Choi, the claimant was transferred to the legal documentation unit. He was previously employed in the funds transfer department for many years, even got promoted there from general clerk position. But when he transferred to the legal documentation unit, his performance became unsatisfactory. And that went on for more than 1 year. So what did the court say? The court said there was a time limit as to how much time should have been afforded to the claimant to improve. And in this case, the court found that the claimant had exceeded all reasonable limits. So as in this case, Mr. Cheng did not adapt in the new department even after 2 years. So while the Citibank case took 2 years before the employee was dismissed, in this CIMB Bank case, Akim Rungkyu, the employee had been performing poorly for 5 years, and the bank presented ample evidence of what I call the positive approach. This is what the bank's witness testified. So you will see that these are all the positive approach actions taken by the bank, and that is why the bank succeeded in this case. The bank's witness said, "We provided all sorts of support, assistance, guidance to him throughout the years in issues such as having discussion of his development plan, conducting mid-year and annual review, giving and providing advice and feedback on his performance, and also coaching and guidance, etc., towards achieving his targets, as clearly evidenced and admitted by the claimant in the performance appraisal. In addition, the bank during those years had also provided and accorded to the claimant numerous training courses and coaching sessions, sales and marketing talks and seminars with all intents and purposes to assist him to improve his performance." So are you here today to improve your performance? So in the CIMB Bank case, the bank exhibited a list of the courses and training that had been attended by this poor performer before they terminated him from service. So that surely was evidence of sufficient warning and sufficient opportunity to improve. Okay. Ladies and gentlemen, there are two types of employees for whom you do not have to strictly apply the legal requirements set out in Eureka Construction. Remember the three-limb test in Eureka Construction? You do not have to strictly apply these tests to two categories of employees. Who are they? Number one, probationers. Number two, senior level employees. I'll share with you the cases that tells us this. For probationers, the High Court in the case of Harta Lega held that, and this is what the High Court judge said, "To my mind, it was wrong for the claimant, for the chairman of the industrial court to adopt the principles in Eureka and Rooftech, which only refer to confirmed employees." This is what the High Court said. "My opinion is that the rigid test as expounded in the said case should not be applied to employees on probation, especially with regard to requiring a written warning. To me, the monthly appraisal report produced by the applicant, which was communicated and discussed with the respondent, was sufficient for reason of dismissal." So that doesn't mean now, ladies and gentlemen, because you've attended this talk and saw this slide, you go and dismiss all your probationers for poor performance without giving them any warning. What it means is, as long as there has been some evidence of communication or discussion or appraisal regarding the poor performance of the employee, then it's lawful to terminate. So the need for that positive approach and all those steps, right, that I've described earlier, the need for that is much lesser for a probationer. Okay? So the Harta Lega case in the High Court has subsequently been followed by many industrial court cases regarding probationers. Right? So the strict tests in Eureka Construction and Rooftech has not been applied for probationers as much as it was before Harta Lega. So the second category of employees for whom you don't have to apply the Eureka Construction test is senior level employees. For senior level employees, the industrial court has, as far back as 1992, in the case of United Oriental Assurance in Berhad against Kamala Rangitan, had adopted the principle from the English case of James and Waltham Holy Cross, which said this: "Those employed in senior management may, by the very nature of their jobs, be fully aware of what is required of them and fully capable of judging themselves whether they are achieving that requirement. In such circumstances, the need for warning and an opportunity for improvement are less apparent. In such circumstances, a warning and opportunity for improvement are of no benefit to the employee and may constitute an unfair burden on the business." So there you have it. There's no strict requirement to follow Eureka and Rooftech when you have a senior employee. Okay? Now, in the last few minutes that I have with you before the clock stops, I would like to walk with you through some pitfalls to avoid. And these are pitfalls that I have picked out from various industrial court cases. If I finish in time, we might do another riddle where I can read your mind. Okay, first pitfall to avoid: don't give a prior assessment of very good if you're about to terminate the poor performer, especially not 2 months before termination, right? So I know sometimes the employee is given a good rating, like meeting expectation, even though he's actually below expectation, right? And you know why you do this? You put meeting expectation, why? In the hope that this person will be motivated to improve, right, in order not to destroy his or her motivation level or confidence level. You hope that putting meeting expectation, even though he's below expectation, you give that rating. But bear in mind, if you do that, you cannot terminate in the near future. Okay? If you want to be kind, if you want to give a rating that is not accurate, slightly higher than what that employee deserves, you cannot terminate in the near future. You have to wait until the next round of review. Right? So that is what happened in the case of Lim Tiong Yen and Expeditors Malaysia. He was given a very good assessment, and then 2 months later, the company terminated his services for poor performance. And there, the company lost the case. Okay, another pitfall to avoid: make sure that the performance problem is not caused by internal systems weakness. It's very easy to blame the employee, right? So look for possible causes other than the employee and fix those causes, especially if it's a systems problem. And this is what happened in Pioneer Concrete and Martin Chia. The company cites that the performance of the claimant was unsatisfactory. The company cited 2 separate incidents to prove this. The first relates to the claimant's failure to get a customer's acknowledgement of the supply of the concrete to the customer. The fault was not with the claimant, but there was a weakness in the system itself, as it allowed the customer to acknowledge retrospectively. Next pitfall to avoid, a very important one: condonation. In the case of Edaran Saga, the company issued 2 warning letters in May 2003 concerning poor performance. So May 2003, 2 warning letters. Then in April 2004, the employee was given an increment of salary. 2 warning letters in May 2003, then in April 2004, salary increment. Then 10 months later, in February 2005, the company issued termination letter for poor performance, relying on the 2 warning letters in May 2003. So this is a problem because the court held that the past performance had been condoned. Condoned by what? By the salary increment that you gave, because the salary increment is based on performance. So you're acknowledging good performance after the 2 warning letters, so later you can't rely on those 2 warning letters in the past, because that is condonation. Okay? Next pitfall to avoid: avoid giving misleading signs. Some people think this is a problem confined to females only, but it's not. Avoid giving misleading signs where you give pay increase, you give promotion, and then 1.5 months later, you terminate the employee for poor performance. So all these are misleading signs which indicated that the employee was actually performing well. Okay? So that is what happened in Nur Hayati, Abu Qasim, and Rashid Asari. The claimant was employed by the company as legal assistant and confirmed in her position. Upon confirmation, she was given a pay increase from 2,700 ringgit to 3,200 ringgit. Then she was given a promotion in the year 2000 to be branch manager. Salary increased to 4,100 ringgit. Then in 6 months later, she was given another pay rise to 5,000 ringgit. And this 5,000 ringgit increment was just slightly more than 1.5 months before she was issued a show cause letter prior to termination. So this is what the court said. She could not have suddenly become a poor performer over such a short period without any rhyme or reason. The company should have found out why and offered her remedies rather than ship her out in such haste, which was not premised on any known law. So here is where the company failed to undertake the positive approach test I was talking about, and the best practice guide earlier would have helped. So I come to the last pitfall to avoid. If the employee has shown improvement, ladies and gentlemen, then you cannot terminate. You have to be fair. Your positive approach actions might have worked. And if it has, if you have seen improvement in performance, you cannot terminate. And this is what the third limb of the Eureka construction test is all about. Remember, there's a third limb, and the third limb is if the employee fails to improve, then only you can terminate. So if the employee manages to improve his or her performance, you cannot terminate, right? So in Lim Kok T and HSBC, the court said this: based on the evidence adduced, the claimant had improved significantly in his achievement of financial target for year 2003, and he was short of only 4% of the minimum target of 90%. As such, the company had failed to prove on a balance of probabilities that the claimant's performance was unsatisfactory. So there you have it, ladies and gentlemen, all the pitfalls that I managed to pick out from a selection of cases. So you now know that an underperformer gets a lot of attention, right? Because of the legal requirements in Eureka construction, in roof tech, the positive approach, the positive actions that I've been talking about. So an overperformer, on the other hand, a hard worker like you and I, sometimes we get hardly noticed at work. And so before I step down, let me read to you this story from the New York Times. Worker dead at desk for 5 days. This is how the story is. Bosses of a publishing firm are trying to work out why no one noticed that one of their employees had been sitting dead at his desk for 5 days before anyone asked if he was feeling okay. George Turkelbaum, 51 years old, who had been employed as a proofreader at a New York firm for 30 years, had a heart attack in the open plan office he shared with 23 other workers. He quietly passed away on Monday, but nobody noticed until Saturday morning, when an office cleaner asked why he was still working during the weekend. His boss, Elliot Wachowski, said, George was always the first guy in each morning and the last to leave at night. So no one found it unusual that he was in the same position all that time and didn't say anything. He was always absorbed in his work and kept much to himself. A post-mortem examination revealed that he had been dead for 5 days after suffering a coronary. Ironically, George was proofreading manuscripts of medical textbooks when he died. The moral of the story, you want to give your co-workers a nudge occasionally. And don't work too hard. Nobody notices anyway. Thank you, ladies and gentlemen. I hope you've been suitably entertained. I think I finished ahead of time. Nobody is here to... Shall I introduce my friend Selva Malar, or shall I take questions? What do you want me to do, Alvin? Okay. Don't say the details. Take questions? No, actually, I'm in a panel discussion later. So if you have very complicated questions, and if you want to find out how I did the mind reading game, then, Sel is here. I'm done, Sel. So I will step down. You can reserve your questions during the panel discussion, and then hopefully you get to go for lunch earlier. Okay? Thank you again.